Hi, I'm Anthony Diosdi. I'm a tax attorney in San Francisco with over 20 years experience in international and domestic tax planning and tax litigation. You can find me at sftaxcounsel.com.
Today, we'll be talking about deportation from the United States for tax crimes. And this conversation itself will be limited to individuals that are in the United States as permanent residents or green card holders, or individuals that were recently granted citizenship. So let's first talk about how somebody can be deported from the United States. When I talk about deportation, I talk about deportation in the context of a tax crime. This could happen to somebody who is a green card holder who wound up committing an aggravated felony. And an aggravated felony for tax purposes involves tax evasion under Section 7201 of the Internal Revenue Code. And it involves a revenue loss to the United States or any government within the United States, meaning that involves a state government as well, and the revenue loss associated with the tax evasion exceeds $10,000. If you have a person that's a permanent resident and they are found guilty of a tax crime, such as tax evasion, and the amount of tax loss to the government, meaning the federal government and state governments, is more than $10,000, that could wind up resulting in a deportation. Now, another way that a permanent resident can be deported from the United States if they wound up on their U.S. tax returns providing a fraudulent or false statement, which amounts to the filing of a false tax return. So you have a permanent resident who files a return that is fraudulent, false, such as omitting income on a tax return or not reporting certain sources of income, particularly, let's just say, foreign income. And that individual winds up becoming convicted of a tax crime for filing a false tax return. That also can result in an automatic deportation from the United States. Now, there's been a lot of talk recently about US citizens being deported from the US for committing a number of crimes. And how can this happen under law? Well, this winds up impacting individuals who have recently become US citizens, but may have lied on their application for citizenship. And let's just say there is a question on the application for citizenship that asks about filing of previous tax returns. All tax returns filed correctly. Was all income taxes that are due to the United States or any state government, was that all paid, or is any outstanding balance that has not been satisfied? And let's just say the applicant winds up not answering that question correctly. So if the government were to discover tax returns that were filed by a permanent resident, income wasn't reported on the return, or the returns were prepared incorrectly, and that individual ultimately winds up facing a prosecution for tax evasion and or filing false tax returns, and therefore become citizens. But this happened before they became citizens, and let's just say the government takes the position that the application to become a citizen was not prepared correctly or lied on that application, that individual could also be subject to deportation. Now, I've heard the Department of Justice speaking about this for many, many years. I know this is kind of a more of a topic that's been recently raised in the news and by the administration, but this has been on the books now. This has been discussed with the Department of Justice for many years. So in an event, if you are a individual that has recently become a U.S. citizen and you may have some concerns about the previous tax returns that you may have filed with the Internal Revenue Service or the state government, and you're concerned that they weren't properly prepared, and you're concerned about an audit, then this is something to kind of take in consideration. So now let's just say you are either a newly admitted US citizen or you're a green card holder and you are concerned about the tax returns that you filed and you are concerned about the possibility of a deportation if the returns that you have filed wind up ultimately becoming audited by the IRS, what can you do now? What is your options that you can do now? Well, there are two major options available to individuals that are in the United States that have filed returns with the IRS and the returns itself, for whatever reason, were not prepared correctly. And one is called the streamlined filing compliance procedures. And what that is that if you have foreign assets or foreign income that was not properly reported on a US tax return, and let me back up a minute there and say that as a US person, whether you are a US citizen or whether you are a US person because of your residency and you have a green card, you are taxed on your worldwide income. What this means is that your worldwide income is subject to taxation no matter what country you're receiving income from. Secondly, there's a number of complicated returns that need to be attached to your returns to report certain types of business transactions or certain types of gifts that you may receive from abroad. So let's just say you have an interest in a foreign corporation. Well, that interest in that foreign corporation will probably have to be disclosed to the IRS on a Form 5471 or a Form 8621. Likewise, if you have an interest in a foreign partnership, if you have an interest in a foreign trust, that foreign trust needs to be disclosed on a Form 3520 or a Form 3520A. If you have an interest in a foreign bank account and the value of that foreign bank account exceeds $10,000, you need to attach by law what's called a FinCEN 114 and possibly an 8938 to your tax returns. And if you don't attach one of these returns to your individual return, one of these information returns, then if you get audited, one, you can be subject to some pretty serious civil penalties, but there's a possibility the government can say that you have filed a false tax return because you didn't disclose all of your foreign assets properly on a US tax return. And if you didn't disclose the foreign income, you could also be subject to a prosecution for tax evasion. So one way, as I was indicating earlier, one way of correcting this, if the mistake itself was non-willful, then you can enter into the streamlined filing compliance procedures, make a disclosure to the IRS, include the foreign source income that was previously not reported on your tax returns, and also attach to your tax returns all of the foreign information returns that were not previously reported. Now, there is a small 5% penalty. The 5% penalty is attached to the greatest aggregate value of your foreign assets over the past 3 years that were not reported to the IRS. But that's a small price to pay in exchange for the IRS potentially not auditing your tax returns and for the IRS also not referring your case to a criminal prosecution and potentially having issues with your status as a resident or citizen in the United States. Making disclosure to the streamlined filing compliance procedures is not a guarantee. It's not a guarantee against prosecution, but in certain cases, if the facts and circumstances are such that you didn't willfully uh, that you didn't willfully not disclose foreign source income and your foreign assets to the IRS, this might be a good way to kind of bring your tax returns into compliance and maybe avoid a future audit. Now, the other way of bringing yourself into compliance is what's called the voluntary disclosure program. So let's just say you have US source income that wasn't disclosed on your tax returns. Or let's just say you have foreign source income that's substantial. And let's just say maybe the reason for not disclosing it on your tax returns, it was willful, or it was maybe a little bit greater than non-willful. Then it may be beneficial for you to consider making a disclosure to the Internal Revenue Service through one of the voluntary, either domestic or a foreign-based voluntary disclosure program to the Internal Revenue Service. Now, By making a disclosure to the IRS, what you would do is you would amend your tax returns for the past 6 years, attach any foreign, if this one's applied to your case, any foreign information returns that was previously admitted, and you pay your back taxes to the IRS along with any penalties and interest that apply within that program. It's not a guarantee that the IRS will not recommend prosecution to the Department of Justice, but in many cases, this could be a really, really good way to kind of come into compliance with the Internal Revenue Service and maybe significantly reduce the probability of a criminal prosecution and potentially significantly reduce the probability of having an immigration issue. I hope that you found this video to be helpful. As always, keep in mind that this discussion itself is not an invitation for an attorney-client relationship. This discussion is meant to be purely for informational purposes only. Thank you.